So good afternoon, everyone, and welcome to today's webinar, Handling Employee Resignations. I'm Fiona Herrell. I'm one of the partners in the Employment and Immigration team here at Brodies, and delighted to be joined today by Gillian Mayer and Louise Usher, another two of the team members. So today we're talking about handling employee resignations. Why are we talking about that today? Well, there has been a huge amount written in the press recently about this concept of the Great Resignation and just how many people are perhaps thinking about leaving their current workplace and current employer to pursue new opportunities. And I think that in part is stemming from individuals reevaluating their lives and their lifestyles as a result of the pandemic and lockdown. I think that's certainly part of it. And I think also now we've got combined with that individuals perhaps taking advantage of what seems to be a fairly competitive job market, and in some sectors what's being called a war for talent, and realising that if they move to another employer then there might be sort of more money available to them, or different opportunities. And of course some people are just leaving the workplace because they're feeling a bit jaded of it all and are thinking about pursuing different career opportunities or different career paths completely. So there's a whole myriad of factors as to why people might be resigning within your business at the moment. But what's clear to us as employment lawyers who act for employers across most sectors and across a variety of different geographical locations in the UK is that there doesn't seem to be any sector or geographic location which is not impacted by this. So that's why we're talking about it today. In terms of what we're going to talk about, got the agenda on the slide. Won't read it out to you. I will explain the aeroplane icon. So when I was looking through our icon bank, I couldn't really find something that was appropriate for resignations with immediate effect or employees refusing to work your notice. So it's a bit of a sort of out of the box thinking there, and it's an individual who has got off on a plane to go on their holidays rather than working their notice period, in case anybody's wondering why I've got an aeroplane as the icon next to the second item on the agenda. So let's get started, because we have got quite a lot to cover. The way we're going to set today's session out is actually in a sort of case scenario. So we've got a hypothetical scenario, and for the purposes of the next 30 minutes, I'd like you to imagine that you are the HR manager at Tastebox Limited. You have just finished a Teams call with one of your recipe developers called Rebecca. Rebecca returned from maternity leave in September last year. She has made a flexible working request, which was refused by her line manager. And today she's just called you out of the blue to complain about comments that have just been made to her by her line manager. You got the impression that she's pretty much come off the call with the line manager and called you straight away. She was very upset on the call, and during the course of the call, she's told you that she wishes to resign with immediate effect. So that's the sort of backdrop, and I'm going to ask Louise to start us off by setting out some of the considerations that apply when we're dealing with heat of the moment resignations.
Thanks very much, Fiona, and good afternoon, everyone. So I suppose the starting point is the general rule that a party who has properly given notice of termination has no right to change their mind, and that applies to both employers and to employees. However, it is well established in case law that good industrial relations practice requires an employer or an employee to be given an opportunity to withdraw words of dismissal or resignation once they've calmed down, where those words have been spoken in the heat of the moment. There are particular circumstances that have been identified by the Court of Appeal that might mean that an otherwise clear resignation cannot be relied upon by an employer as having that effect. The first is where the decision has been taken in the heat of the moment, and that might occur where an employee phones you and says something along the lines of "I quit," or alternatively it might be framed in a more in a way that's more akin to an ultimatum, such as "I would rather quit than, for example, continue to deal with my line manager." The second situation is where an employee has potentially been jostled into a decision by the employer. So the employer may have exerted some pressure in an attempt to get the employee to resign. And the final situation is where an employee may be acting under stress, and that might be work related or not work related, for example, a recent bereavement. In a Court of Appeal decision, the Court of Appeal have held that while generally unambiguous words of resignation would lead to the conclusion that an employee has resigned, it is possible that in some cases there may be something in the context of the exchange between the employer and the employee, or in the circumstances of the employee, him or herself, that would entitle a tribunal to conclude that notwithstanding the appearances, there was no real resignation, despite what it might have appeared to be at first sight. So if a resignation appears to have come out of the blue and the employee is raising issues that perhaps they haven't raised before, or appears to have potentially taken a knee-jerk reaction to something that's happened recently, such as, for example, Rebecca just having had this conversation with her line manager, then the best practice is to allow that employee to have a short period of time to reflect. The Employment Appeal Tribunal has suggested that this period should normally be quite short, normally no more than a day or two. So in this example, Rebecca has called to tell you about a conversation that she's had with her line manager. You should send her an email just to summarise the conversation that you've had with her on Teams and ask her to come back to you to confirm what she wants to do in writing within a set time frame. If the employee has left in more adversarial circumstances, maybe they've stormed off site, then you should still try to contact them, be it by phone or by email. And if after that period of reflection, the employee is still clear that they do wish to resign, then you might wish to ask them to send confirmation of that in writing so that you have a written record.
Great. So if we fast forward and we assume that we've now received a resignation letter from Rebecca, and she's saying that further to the conversation yesterday when we said to her that she should take some time to think about it, she's now writing to resign from her role. She's resigning with immediate effect because she can't work under these conditions for a second longer and she has no interest in working her notice period. So Gillian, if you could maybe take us through sort of considerations in relation to resignations with immediate effect and employees refusing to work their notice period, that would be great.
Thanks, Fiona. So first of all, thinking about what Rebecca's notice period might be, there is a 1 week minimum statutory notice period for employees that have at least 1 month's continuous service, but often the contract will stipulate a longer notice period. So the first thing to do is just to check Rebecca's contract to see what her notice period is in the contract. Any resignation without notice will be effective unless it is a constructive dismissal situation, but it will also be in breach of the employee's contract of employment. Another thing just to be thinking out coming out of that first paragraph is that Rebecca's resignation may amount to a constructive dismissal if it is in response to a fundamental breach of her contract. Some of the words that she used there are a bit of a red flag. We don't know all the details at the moment, but she did say that she can't work under these conditions for a second longer and she's got no interest in working her notice period, so that might be a live issue. And then another thing just to be thinking about in terms of somebody resigning with immediate effect is just what is their actual termination date. So the date on which an employee hands in their resignation or sends it by email is the termination date. If the resignation letter is sent by post, then it will be the date on which they anticipate that the letter will arrive in the normal course of post. So those are just a couple of things to think about in terms of the resignation with immediate effect. It sounds as though Rebecca's not going to be willing to work a notice period, so there's a few things to then think about. One option might be to remind her of her notice period and that she is required to work during the whole of the period and confirm that to Rebecca in writing. The other option is that if she still refuses to work her notice period, then you may just treat her absence as unauthorised and not pay her during the period that she would have worked out her notice. But again, if you're going down that route, then we would recommend that you confirm this to Rebecca in writing. If you find yourself in that type of situation, then you might want to also consider whether or not you would want to pursue a breach of contract claim against the employee who's refusing to work their notice. Claims of this nature are rare in practice just because it's quite difficult to prove that a loss has actually been suffered. And there can be quite prohibitive costs involved in bringing this type of claim as well. And another thing that also actually makes this a wee bit more tricky is that this type of claim can only be brought in an employment tribunal if the employee has already raised a breach of contract claim against their employer. If that's not the case, then you would have to pursue this kind of action in the civil courts. So there's a few things to weigh up there as to whether or not that might or might not be an appropriate option in the circumstances.
Great. So if we continue reading on through the resignation letter, we're now being told that she's been placed in an impossible position over the last 6 months. And ever since she returned from maternity leave in September last year, her line manager has been constantly belittling her, that he's refused to grant her request for flexible working so that they could work together on projects and new recipes in person, but that he's only ever giving her administrative tasks, and that he's giving the more interesting work to Jack, who was only ever supposed to cover her role on a temporary basis while she's been on maternity leave. She says she's tried really hard to be a team player, but as we know, yesterday her line manager said that she could have gone so much further in her career if she hadn't taken her foot off the gas, and she simply cannot take any more. So Louise, if you set out for us then what we might be thinking at this point in the reading of the resignation letter.
So we see issues that are arising in the resignation letter that we haven't heard before. If you're the HR manager that's responsible, you're going to need to decide how to deal with this. In cases where there might be a low risk of a tribunal claim, or the thing that's being complained of appears to be either quite minor or perhaps petty in nature, then you might take the view that the purpose of your grievance policy is to assist employees who have a complaint or a concern about their employment. And now, while the employee is on their way out the door, there isn't the same level of opportunity for you to fix the issue that's been complained of. However, in other cases, such as in this one, where you have a potential discrimination issue, a potential constructive dismissal issue, and to put in this case, there's allegations about remarks that have allegedly been made by someone in a position of authority, it appears on the face of it that this may well justify some form of process. Now, the process that you decide to adopt will depend on the circumstances of the particular case. Your grievance policy is likely to provide for an initial grievance meeting with the employee and a subsequent right of appeal. Now, depending on the nature of the complaint that's being made, you may decide that since the employee is leaving employment, a more proportionate response would be to meet those that are named in the complaint and then send an outcome letter without first meeting with the employee. Again, if you've assessed the risk of a claim to an employment tribunal as being relatively low, then you may decide in those circumstances not to offer a right of appeal. If you've decided that you are willing to investigate and to carry out some form of process, then you may also want to reach out to the employee to ask them if they would like you to carry out an investigation. In some cases, they might say no and tell you that they just wanted to get everything off their chest as they resigned. Or alternatively, they might say yes, but in either case, it's going to give you a better indication of what their mindset is in terms of how likely an employment tribunal claim is. If the employee tells you that they don't have any interest in participating in a complaints or a grievance process, then you might decide that you're going to investigate it anyway. I'm sure that no one on this call is looking for things to be added to their to-do list, but it may be a means of avoiding similar issues from arising in the future, and also may mitigate any risks just in case the employee does decide in the future that they do want to take the complaint further. So what are the advantages of following a complaints or a grievance process? Now, the first is that it may deter employment tribunal claims. If we take the example of Rebecca, she claims that her line manager has said that she's taken her foot off the gas. But if asked about that, her line manager may deny making those complaints completely, or he may say that what he has said has been taken completely out of context. Grievances, I think, often on the face of it sound terrible, but as we all know, there is so often another side to the story. It might therefore be beneficial to have a written record of what that other perspective is, with a conclusion reached on the allegation that is being made. If you choose not to do that, then there is potential for you to give more breathing room to a complaint than is perhaps warranted in the circumstances. And if Rebecca's thinking about bringing an employment tribunal claim, setting out both sides of the story in that way may make her think again about what it is that she wants to do and the challenges that she might face if she does decide to pursue an employment tribunal claim. Another reason to investigate a post-termination complaint is to ensure that issues are being properly investigated by the business. So if Rebecca's line manager did make the comments that she alleges and did effectively chip away at her role, then it might be important for you to understand why that has happened. Does the line manager or management more generally need more training on equality and diversity issues, or perhaps how to deal with flexible working requests? If you don't investigate the issues that are being raised, you may not know the answers to those questions, and Rebecca's line manager may well go on to repeat that behaviour in the future, leading to other women resigning from the organisation, which ultimately in the longer term could be very bad for business. The third advantage of considering following a process for a complaints or grievance that's been lodged or raised is that the Employment Tribunal will expect employers to take account of the ACAS Code on disciplinary and grievance procedures. So if an employee does subsequently raise an Employment Tribunal claim and an employer's failed to properly investigate that complaint, then a tribunal can award an uplift of up to 25% to any award of compensation that it grants. Now, there's no explicit requirement in the ACAS code for an employer to follow a grievance procedure in cases concerning former employees, but there is one case that's been heard before the Employment Tribunal where an uplift of 25% was granted because an employer failed to deal with or even respond at all to a grievance that had been raised by an employee after her dismissal. Now, that decision isn't binding on other employers, but it does suggest that it may be advisable to follow some form of process when considering a complaint that's been made in this context. If you were to decide to follow a more streamlined complaints process, such as responding on the basis of the papers or deciding not to offer a right of appeal, that might certainly be appropriate in the circumstances, but you should be mindful that if there is a high risk of a claim, then that's something that the former employee might seek to refer to in their complaint, that essentially any compensation that an uplift should be granted to essentially reflect the parts of the process that you've chosen not to follow. The final point that I would make is that failing to deal with a grievance where the employee has complained of discrimination may in of itself amount to an act of discrimination or victimization. So on the face of it, Rebecca appears to be complaining of sex discrimination. If you've dealt with other grievances from other former employees in a different way, and then you decline to deal with Rebecca's, she might argue that you are subjecting her to a detriment because she's made a complaint under the Equality Act, and that in of itself could be a freestanding claim. So that's something to bear in mind. On the other hand, though, there are some disadvantages to following a process. As you'll all know, grievances can take up a significant amount of time, and that's not just your time, but also the time of anyone that's named or otherwise implicated in the complaint that's been made. I've outlined the risk of a 25% uplift to any compensation, but failure to comply with the ACAS code isn't in of itself a freestanding claim. The employee needs to have a claim that is going to be successful in order to benefit from that uplift. So if you know that the points that are being complained of are spurious or without merit, then you might decide or take the view that following a process just isn't worth the amount of time that it will take. If an employee separately has already raised the issues, perhaps as part of another grievance process, and is simply reiterating these on their way out the door, then you might take the view that it's not necessary to look at those issues again at that stage. And finally, while I have spoken about the advantages of following a process and that it might deter an employment tribunal claim, you should also bear in mind that engaging with an employee in a grievance or complaints process can go in the other direction. So taking Rebecca, for example, she may well become more aggrieved after hearing her line manager's perspective. If her line manager were to say that he tends to give more work to Jack because Jack is actually more talented than she is, then she may become even more entrenched in her position, and that might strengthen her resolve to bring an employment tribunal claim.
Yeah, so definitely lots to weigh up in that situation as to the complaints that she's raising in the resignation letter. Just moving on then to the next issue that we need to think about is the fact that she says she's looked at her contract. She can see that there's a clause in there that says she can't work for a competitor for the next 12 months. But as is often the case, she has a friend who works in HR, and she's been told that we can't enforce the clause because the company's treated her so badly and because she's not senior enough to justify the kind of restriction. And she gives us a heads up that she's seen another vacancy for a recipe developer role, and that they say on their job advert that they're willing to accommodate flexible working, so she intends to apply for it. So Gillian, can you talk us through the considerations arising now, please?
Yeah, so I think the first thing to do is, again, just have a look at Rebecca's contract to see what it says about post-termination restrictions. It sounds as though Rebecca certainly thinks that there's some sort of non-competition clause in her contract, so you'd want to check the detail of that. There are other examples of restrictive covenants which I've got on the screen. But for the purposes of this example, we're just going to be looking at the first option, so a non-competition clause. So this kind of non-compete clause will be invalid if its sole purpose is to restrict competition. So there has to be some sort of special justification for it. And traditionally, these sorts of clauses have been quite difficult to enforce. But increasingly, there's a move away from that approach, particularly where there is some sort of confidential information that has to be protected, or where a different type of covenant will be ineffective. So as the starting point, can the restrictions, any restrictive covenants contained within Rebecca's contract be relied on? Not necessarily. A contractual term that restricts an employee's activities post-termination will be void unless you can satisfy a court of two things. So the first is that you have to be able to satisfy a court that the covenant has been designed to protect a legitimate business interest. What do we mean by legitimate business interest? Well, it could be goodwill, it could be trade secrets, or some other type of confidential information. So that's the first part of the test. And the second part of the test is that the restrictive covenant must extend no further than is reasonably necessary to protect that interest. So this is really all about the covenant being restricted by reference to specific activities, perhaps that the employee can't do, the period of time that it will be in place, and or the geographical scope of any covenant as well. And if the two limbs of that test haven't been satisfied, then the covenant will be deemed to be void and unenforceable. So your starting point is wanting to think about the restrictive covenants around Rebecca's contract and whether or not they might be enforceable. Unfortunately, there's no hard and fast rule. These covenants do have to be considered on a case-by-case basis, depending on the business needs and also depending on the individual employee involved as well. Some other considerations, a covenant's reasonableness will be determined at the date that a contract was entered into with the employee, not at the point at which the employer is looking to enforce it. So that's an important thing to bear in mind. If the employee was hired with a sort of fast track promotion expectation, then it may be that the covenants could still potentially be enforceable at the point of termination. But if the employee started in a very junior role and there was no such expectations, then that's going to factor into the enforceability or otherwise of the covenants. It's also just really important to think about how long the covenants are necessary to protect the business. So normally for the type of non-competition covenant that we're looking at, a period of 3 to 6 months would normally be appropriate, and only 12 months might be justifiable for a particularly senior employee. Thinking as well about the geographical restrictions that have been written into to Rebecca's contract of employment, and the reasonableness of those will depend on the sector within which you're operating and the interest that you see as being protected. And one other thing just to remember is that if Rebecca or another employee resigns in response to a repudiatory breach of contract, then the employer will not be entitled to enforce any restrictive covenants. So this is a sort of hard and fast rule in Scotland. In England, there has been some situations where the courts have disapplied this rationale, but in Scotland, the rules have been followed quite robustly. So some options then when an employee such as Rebecca is looking to leave and there are restrictive covenants in play, the first thing that you can do is remind employees about what their post-termination obligations are. So just writing to them, perhaps asking them to sign some sort of undertaking, or even writing to their new employer to let them know what the covenants are that are in place. Second option might be asking an employee via a settlement agreement to enter into new restrictive covenants, but obviously you'll have to make some sort of payment, or there'll be some sort of reason for the employee to want to enter into that. And finally, just thinking about whether or not you might want to take action to try and enforce the covenant. So that will depend on whether or not you think they're enforceable in the first instance, and also depending on whether the breach is something minor or what you consider to be more serious. A solicitor's letter might be appropriate in the first instance, but ultimately you might also consider raising a claim for damages as well against the employee or against their former employer, depending on the circumstances. So those are just a couple of options to be thinking about on termination.
Great. And so we get to the end of the resignation letter, which is her telling us that she's still got her laptop and her work mobile at home, and she can't face saying her line manager she won't be coming into the office again to return these items. I mean, I think really just the point coming out of that, obviously, is there's lots of loose ends to be tied up when an employee is resigning and their employment is coming to an end. Return of company property is just one of those items. And of course, with everybody having been working from home, they will have equipment at home that they wouldn't otherwise have, but they might also have more of your confidential information, trade secrets, documentation at home. So making sure that you've got really robust procedures in place for getting all of that back. So if we can just go on to the next slide. I think summarising it all, then we're probably in a position where when the resignation letter lands, you're having a discussion with the employee about their resignation. There may be an opportunity to try and retain them. In Rebecca's case, I think that's probably a lost cause. We're not going to be able to change her mind, I shouldn't have thought, but in some cases it might be possible, so worth having that conversation for sure. Some sort of letter to them setting out, or rather acknowledging their resignation and setting out the arrangements that will apply. It's not the case that a resignation has to be accepted. So the letter is not really to ensure that the resignation is effective, but more just that there's clarity as to the arrangements that will apply. So things like, is the individual going to be required to work their notice period? Obviously, Rebecca saying she's refusing, she's resigning with immediate effect, but in other circumstances, would you want the individual to work, or would you have them on garden leave, or would you be making a payment in lieu? What's the position in relation to holiday? Are you requiring them to take holiday, in particular if they're working their notice period or if they're on garden leave? As Gillian said, a reminder about their ongoing obligations of confidential information and restrictive covenants, and that would be as standard, even if the individual hasn't indicated that they would be moving to a competitive role or seeking to move to a competitive role. Always good just to remind people about their ongoing obligations. Clearly, if they're a statutory director, you want to tie that up at the same time, whether or not you're going to have an exit interview. And then you click into your standard leaver process, obviously around things like IT access and access to buildings. There's a huge amount of information on WORKBOX on this topic. So WORKBOX by Brodies is our online employment law and HR portal. So if you're a WORKBOX by Brodies user, we've just put a screenshot from the site there so you can see all of the content that's there. If you're not a user and you would like to have a demo of the site and then trial access, you can see what's there, then please do just let us know and we can get that organised. We've got some questions which have come through, which we're not going to get time to answer them all, but we'll answer the first one which came through, which is, what if you're happy for the individual to go and not work her notice? Do you need to pay her anything? I think it's a really great question. So obviously she's resigned with immediate effect. we sort of assumed that we might want her to work her notice period. If she doesn't, then I think we could just send her a letter saying, under your contract, your notice period was X weeks. You've indicated you're resigning with immediate effect. We're prepared to let you go on that basis, but you won't be paid. And the reason you do it that way is just to avoid there being any sort of suggestion by other employees that there has been a precedent set, because what we don't want is for people to think that they can just resign with immediate effect and that we won't at least consider what their notice period is and the amount of notice that they should have given us to bring their employment to an end. There's a request for the case where we talked about the 25% uplift, so we will circulate that after the session when we send round the recordings. Conscious of the time, so we'll bring the session to an end there. Thank you very much indeed for attending. I hope you found that useful. As a recap of handling employee resignations, immediately following this session there will be a prompt that appears which asks you to complete a short survey. It would be fantastic if you could do that. I'm told there are 6 questions. It takes less than a minute to complete, and one of the questions is asking about how you like to receive content from us, and in particular, do you like to still attend webinars, or would you be liking to attend more in-person or hybrid events? Because we're just thinking about the future of our webinar programme. So if you could complete that, we'd be very grateful. And otherwise, have a great Wednesday afternoon. Thank you, everyone.